like to ask Mr. Kamal Shukri to begin this session, to start us with the legal environment for investment in Saudi Arabia.
Thank you so much, Mr. Hussein Shubukshi, for this opportunity. And it's very well known for lawyers to bore people and also make things so difficult in order for them to gain their business. In this forum, I'm trying to avoid this and try to put and lay the facts for the investment in our country in order to how to understand and also make sure that you are on the safe side. Saudi authorities regard the foreign investment as key of its long-term economic growth and success. And surely for the Czech Republic investors, there are mutual benefits in investing in the Saudi market. This is being enhanced by the encouragement and reciprocal protection of the current investment agreement that been entered between the two countries since November 2009, whereas the main purpose to its intent is to intensify the economic cooperation and create favorable conditions for investments by investors of either countries in order to stimulate the private business initiatives. I am here today to discuss what are the current available legal structure for foreign investors. For foreign investors, they can choose to practice their business in Saudi market by either indirect investment or direct investment. Forms of indirect investments for foreign investors to indirectly enter the Saudi commercial market and present their products in the market. There are many forms in which the investors may do so. The most popular and common forms are agency or commercial proxy agreement for foreign or national project, commercial distributions agreement, and the commercial and the for franchise and the franchise agreement. All these agreements have to be entered between a foreign investor who own a brand with 100% owned Saudi commercial entity in return of fees or commissions. These agreements shall be recognized and enforced by the Saudi government after they have been officially registered with the authorities such as Ministry of Commerce and Industry. Recently, the Saudi legislation body has requested from the Saudi Capital Market Authority, CMA, to draft requirements and rules to entitle certain qualified foreign financial institution for the right to invest and trade in the shares of publicly listed companies in the Saudi capital market. The legislation is set to take effect in mid-2015. There are several conditions for both foreign investors and Saudi companies to consider in launching their business under the agreement. This kind of investment has its pros and cons, and definitely it will not allow a lot of investors to have the direct day-to-day interact with their business through the agencies or the other forms of agreements to do business indirectly in Saudi. In order to do, there is also laws and regulations which are have to be taken into consideration. There is for the foreign investments which are not officially registered with the local authorities, and they should be subject and sometime to penalties of the anti-concealment law proclaimed by the Royal Decree number M22 since 2004, in which the violators are subject to some heavy punishments if they go that direction. For doing direct investment in Saudi Arabia, there should be licensed through SAGIA, which is the Saudi Arabian General Investment Authority, in which this is the gateway, as a matter of fact, to the market. And in doing so, the investors shall be required to identify the legal entity it desires to structure for the business practice and kingdom. The licensed SAGIA entity may take one of the following terms: either a joint venture with a local partner or 100% foreign owned. The available legal structure for SAGIA licensed entity are either a sole establishment or company that owned by person or company owned by persons or company owned by persons and companies or company that owned entirely by companies. Also, there are foreign company branch and technical scientific offices. Such entities, whether owned by Saudi national and foreign investor or 100% owned by foreign investor, shall select the activity type. They are summarized in the following: industry activity or commercial activity, agricultural, contracting, real estate, specialized service activity, non-specialized service activities, insurance, reinsurance, and management of construction projects, and engineering, procurement, and construction EPCs, known as EPCs contracts. Each of the above activities required a special license of a minimum capitalization and may sometimes require a Saudi partnership percentage in the company shares, depending on the type of activity. I think this slide can clarify some of the issues that has to be taken into consideration to enter the market. SAGIA responsibilities, basically, it has several tasks that vary from issuing and updating laws of investment, licensing foreign investors who successfully complete the application requirements, and connect investors with all government entities in which the investors are going to deal with, supervise licensed investors to make sure that they are complying with the business plans specified for their investment and already submitted through the requirement that SAGIA places beforehand, and approving changes of activities requested by licensed investors, as well as updating the list of excluded activities from foreign investment, which we call it the negative list. The strong legal foundation is the most important element that shall convince foreign investors to trust the Saudi market. There are laws, regulations, and guidelines in which governing the relationship between the foreign investors and local authorities. The latest SAGIA Board Resolution number 2/74, the most important document for investors to follow. This is a fresh regulation that has been passed recently, containing 22 articles, which rectified the shortcomings in the previous regulation. For example, modified the articles related to the sponsorship of foreign employees, the legal structure to the Saudi markets, giving SAGIA the power to efficiently and effectively license any form of foreign investments activities that were not allowed to foreign participation earlier. There is a negative list that has to be taken into consideration for businesses which are not and still not allowed to be practiced in Saudi Arabia. This is being also evolving to minimize the restriction in the future and open the doors to such activities with special licensing and special contacts directly with the government. I am here actually also to talk to something which is really developing in the market, and that was since 10 years ago, there were some laws and regulations that opened the way to the economic, what they call it actually, the economic cities. These are industrial, financial, technical, medical, and commercial cities in different parts of the country. Recently, 3 of these cities are existing and basically operating. These cities are namely King Abdullah Economic City in Rabigh Port. There is Medina Technology City and Jazan Heavy Industrial City. Most active city currently is King Abdullah Economic City in Rabigh, which is also next to one of the largest ports in the Saudi Arabia right now. It's almost 3 times, its capacity is 3 times the capacity of Jeddah port, and in which commercial, industrial, and exporting businesses are currently setting up and making very good achievements. Foreign investors, as well as Saudis, can establish businesses within these economic cities. Both will have to follow the same licensing procedures outlined in the Foreign Investment Act of Royal Decree number B/2943. SAGIA will be the only contact point for investors and residents in the economic cities, and will provide all governmental services through the smart service centers. And this is very important, actually, which is also known as the one-stop shop. And that makes much more easy and efficient way for an investor to contact and coordinate with the different government sectors, and ease the bureaucracy to its minimum as much as possible. In the meantime, all investors wishing to establish economic cities will be served through the existing smart service centers located in all major cities within Saudi Arabia, which is namely Riyadh, Dammam, and Jeddah. The SEC, which is the Smart Centers, currently offers more than 128 governmental services and is continuously enhancing its basket of services. I'm also something which is very important to address here: corruption. Corruption remains a significant issue that Saudi government is addressing head-on. Since 2011, a royal decree established an anti-corruption commission to monitor government departments. The kingdom is exerting relentless efforts to fight corruption, and the authorities are making putting really a very hard punishment on any violators. In addition, the Saudi government has put relentless efforts to reform the existing judicial system by updating laws and regulations and training of judges and clerks, along with openers of capital markets for foreign investment. And finally, my recommendation, to summarize: basically pursue a clear feasibility study of the market, which is very important. Secondly, make sure that any investor's business plan is aimed at creating more jobs and training opportunities for Saudis, as well as the mutual benefit that you have when you are located in Saudi. If possible, start with a regional branch in the Saudi market, in a field where the investor has plenty of experience, which shall be an added value to the local market, in order to get comfortably acquainted with the SAGIA rules and market environment. There are advantages and less restrictions on foreign investors' business when establishing at the new economic cities, so make use of this. There also utilize the right to own your business properties, in which the kingdom allows as a headquarter and housing for the investor's establishment or entity, which will be considered as indication to SAGIA of your long-term capital investment commitment. Carefully choose your legal and financial and partners when you are into the market. Also, the encouragement and reciprocal protection of the investment agreement between Czech Republic and Saudi Arabia emphasizes on amicable settlement or arbitration in case of any dispute among the parties, which should be considered by the investor. Finally, have faith in our legal system, which has prospered to accommodate the principles of non-discrimination between foreign and local parties within a dispute, as all shall be entitled equally under the law. Wish you all the best, and thank you again, Mr. Shibukshi.
Thank you, Mr. Shukri, for a very insightful and detailed analysis of the legal challenges for investment opportunities in Saudi Arabia. I would like to invite Mr. Ahmed Rida, the financial advisors from Ernst & Young, Saudi Arabia, to take us on a tour of the tax challenges for foreign investors in Saudi Arabia. Mr.
Shukran. Bismillah ar-Rahman ar-Rahim. First of all, I would like to thank Mr. Hussein Shibukshi for the invitation to this great forum, and I wish that this forum would result into a very strong relation between Saudi Arabia and Czech Republic. To be honest, when Mr. Hussein invited me to talk about tax and regulations related to the business in Saudi Arabia, I said, let's give some an overall view on the economy initiatives and the profile of Saudi Arabia as well. So I will talk about a few more. I will just share with you my agenda. First, I will talk about the Saudi Arabia profile, current initiatives in the Kingdom of Saudi Arabia, and then give an overall view about the taxation and regulation related to the tax in Saudi Arabia, and then the conclusion. Let me start with the profile. As mentioned here, Saudi Arabia is the largest economy in the MENA region, which includes the Middle East and North Africa. And Saudi Arabia is one of the G20 major economy in the world. Also, Saudi Arabia allows the free cash in and out, and there is no restrictions related to the cash. There is a certain positive pillars or key point that encourage the Saudi economy, encourage investors to come and invest money in Saudi Arabia, and mainly the geographic location, substantial government investment infrastructure program, focus on the development of social infrastructure, diversification of the economy, large local market and purchase power, and then the world-leading economy and social transformation program. Some of you know that Saudi Arabia has more than 25% of the oil reserve and 1/4 of the natural reserve globally. I'll just touch on some social indicator about Saudi Arabia. The GDP of Saudi Arabia as of now is 2013 is 748 billion, and it's growing by 2020. We expect to grow by 40%, and 2030 it is expected to grow more than 100%. Population of Saudi Arabia is 29 million, and it's expected to grow by 2020 to 33 million, and by 2030 to 39 million. Labor force, it's almost 10 million, and by 2020 expected to go to 12.5, and by 2030 it is 15.6. FDI, foreign direct investment in Saudi Arabia, as of last year, it was $12.9 billion. And we do expect, according to the current economical situation, that will go more. Now let me move to the second point, which talks about this is an overall about the GDP of Saudi Arabia. And we see from 2001 until 2013, there is a great growth happening. And this is what contributed to two reasons: the stable political situation of Saudi Arabia and the growth and the budget of the country. As most of us know, that Saudi economy is mainly driven by the government spending. And I would attribute this great achievement to these two factors. In fact, there is a number of active sectors in Saudi Arabia, and I just wanted to give some of our view on these active sectors in Saudi Arabia. I would say if you see the top line, you will see there is a very huge or big sector which include the communication, power and utility, banks, and petrochemical. These are really big sectors. And if you see in the second line, third line, you will see this is the gross margin and net profit. Most of these sectors in Saudi Arabia are profit making, and this shows the potential opportunity and the other growing sectors. There is two other sectors that we didn't mention here, but we believe they will be very strong in terms of growth, and they are the main focus of the government of Saudi Arabia, which are the healthcare and education. Now let me take you to the legal of the entities come to Saudi Arabia. I would say there is different. There is incorporated companies, and there is a branch office. There is a representative office, which include technical and marketing, and there is agency as well. So anyone want to come to Saudi and invest in Saudi Arabia, he has to choose one of these four legal structure in order to come to Saudi Arabia. And I'm sure Mr. Kamal has covered most of these, or has covered all of these. Now let's take you to the tax in Saudi Arabia. We should differentiate of two things in Saudi Arabia. First thing, the resident company and non-resident. Resident company include number of category. The first one is the classic. Any company want to come to Saudi Arabia, either they will be 100% foreigners or they will be a mix between Saudi and non-Saudi. And there is a criteria for what sector these foreigners should come and invest, and I guess that has been shared by Mr. Kamal. Other than that, there is an oil company that they could come and invest in Saudi Arabia under certain conditions, and there is natural gas law as well, are identified as an opportunity according to the tax law of Saudi Arabia. In addition to that, there is a natural person. Usually they are professionals, such as doctors or engineers. They could open office in Saudi Arabia, and they have to comply with the tax regulation in terms of filing tax returns. In addition to this, there is something called permanent residence, which doesn't include registered company or a branch, but the government look into these as if they are registered in Saudi Arabia and they have to pay tax in Saudi Arabia. The definition of the permanent establishment, in Saudi Arabia, that it's very simple. Any company or any person has an activity in Saudi Arabia, regardless if he has the legal identity or get the legal approval from the government or no. Anybody who could come and do activity in Saudi Arabia by himself or through or represented by an agency should be considered as a permanent establishment. And by considering this as a permanent establishment, he will be subject to a tax of 20%. And the reason we're saying permanent residence, permanent establishment, is to differentiate between the direct tax and the withholding tax. So any company or any entity could come to Saudi Arabia and do activities would be considered as a permanent establishment, and they have to file a tax return in Saudi Arabia. Other than that, any services done abroad, outside of Saudi Arabia, would be considered as an entity that should not pay income tax, but they should pay a withholding tax. And the main difference between these two, that is the tax rate. The other one pays almost 20% on their net income, but the company that doesn't have a permanent establishment in Saudi Arabia, they would pay a tax between 5 and 20%. Now, this is just small overview on what's going on inside the country and government spending. These some of the sector that government is heavily investing on. So I won't take time because it's really, I'm running out of time. Here, again, I'm just repeating whatever I said before, but the only reason I would like to, the only point I would like to state here, for Saudi and other Gulf nationals, that we don't pay tax. We pay something called zakah, which is a Sharia compliance or a religion levy that we pay it. Again, this is the summary of my presentation, a definition of who's liable, and the rate, and the basis of calculation. So any company, just to summarize, any permanent residence, any permanent establishment in Saudi Arabia will pay a tax 20%, except for the oil, will pay 85%, and gas, natural gas activity will be 30 to 85% on the net income, adjusted net income. For the withholding tax, they will pay tax of between 5 to 20% on the value of the contract itself. Effective of 1st of January 2014, there was a signed tax treaty agreement between Saudi Arabia and Czech Republic, and there is definitely certain excellent advantage to the investor coming to Saudi Arabia from Czech. One of the advantage is if any interest, or according to the Saudi law, Saudi tax law, interest will be subject to 5%, but according to the treaty, it will be free of taxation. So this advantage for a financing activity would come from Czech to Saudi Arabia. Another advantage, royalty, according to the tax law, is 15%, but according to the tax treaty, it's been reduced to 10%. So any royalty fee won't be subject to the maximum, it will be subject to a very minimum amount. Technical, consulting and other activities will be not subject to tax, so it will be free of tax in Saudi Arabia. I guess this is a good advantage for certain sector to come and invest in Saudi Arabia. Now, let me take you to the slide before the last one. There is a report was issued by an organization called Doing Business Organization with the World Bank about doing business, and they've ranked Saudi Arabia number 26 globally in terms of ease of doing business in Saudi Arabia. In conclusion, I just would like to mention the strength of the Saudi market and opportunities. I'll just focus on these. It is impressive government support for all business sector, sustainable economy, low tax rate, fair transfer of cash, suitable purchase power, low manufacturing cost. And opportunities, integration of transportation sector, enhancement of financial sector, enhancement of service sector, huge government investment in infrastructure, low land and asset government cost, large focus and investment in education and health care, huge petrochemical industry. I guess this is in summary of strength and opportunity in the Saudi market. Thank you, and it's yours.
Thank you very much, Mr. Ahmed Rida, for a beautiful presentation. I would like to invite now Dr. Jerry Svoboda, CEO, aka Svoboda Law Firm, to take us on the legal challenges and opportunity in the Czech Republic.
So, good afternoon, ladies and gentlemen. My presentation in section is about the legal system in Czech Republic. The Czech Republic is a parliamentary democratic state with a liberal system of government and a political system based on free competition of political parties. We have a constitution of Czech Republic, which is a fundamental law. Just a second. Containing basic principles by which the society is to be bound, which contains the basis of the state organization. Constitution separates into standard powers as attribute of democratic state, which I briefly will inform you. So the legislative power is the parliament enacts all the laws in the legislative process, in which both chambers of parliament and the president participate. The president has a right of veto that can be overruled by the chamber of deputies. You can see basic description of parliament consists of chamber of deputies and senate, and basis rules of election into it. The executive power performs a public government, and particularly is represented by the President of the Republic as the head of the state, and the government, which is the supreme executive body which administer the country through ministries and other administrative authorities. Here you can see which ministry we have. It's a standard division. We differ between public state administration and local administration held by the local government, divided by principle of territorial. State territory is divided into self-governing units for 14 regions, and the second division could be the principle of interest basis, such as professional chambers. The judicial power is generally guided by the principle of independent and impartial tribunal and judge, principle of public and direct hearing, oral proceeding. The judicial system consists of common courts and the constitutional court, serving to protect the constitutional order and fundamental rights and freedoms. We have three types of judiciary: the civil, criminal, and administrative courts. The result of proceeding is mostly a court decision, judgment, as an individual administrative act, being always a result of an application of the law, and which is binding exclusively the parties to the proceedings, as opposed to the law, which is binding for everyone. In this connection, I would like to point out the fact that certain interpretation made by the courts that has become standard legal practice is then called constant case law and is taken into account while resolving the same or similar cases. In addition, the Czech Republic is bound by international treaties. The scope of international treaties having so-called application priority means that this is the obligation of judges to give priority of such international treaties, should they learn that such treaties are in conflict with the Czech legislation. Therefore, the independent legal branch, the European law, was formed as a result of primary and secondary legislation, as mentioned, which lawyers in Czech Republic should be familiar with as well. The Charter of Fundamental Rights and Freedoms is attached to the Constitution. It contains fundamental human rights, as you can see. I want to mention that we are religious tolerant to all religions, despite the fact that our society is based on Christian values. These fundamental rights and freedoms may be asserted by everyone and applied to everyone. Then very briefly, right to vote is on the basis of these principles as universal, equal, direct, and is exercised in secret voting. Then let's talk about branches of law in the Czech Republic. So the basic division is to the private and public law as known, as well as substantive law and the law of procedure, or the national and international law. The branches of law, each branch of law regulates a specific area of relationships. For each branch of law, a fundamental law is so-called code, plays the most important role as a civil court or criminal court. Individual branches of law, you can see which law are comprising in the private law and public law. So let's talk about the civil code, because from the 1st January of this year, new civil code and many other regulations being part of the so-called private law recodification, which have been adopted. The new civil code is a fundamental private law regulation which replaces the original civil code from 1964. The aim and purpose of the new civil code is to, with some exceptions, regulate all private law relationships in a single code. The new code seeks to adapt the private relationships to modern needs. The new civil codes contain more than 3,000 sections and is divided into 5 main sections. Most of the provisions have a dispositive nature and respect the principle of autonomy of will. The following, you can see the absolute property rights, which I want to mention. Only the fact that we change the rights of system of immovable properties. The structure is part of a land. Formerly, it was a separate thing, so we're returning to this original Roman law principle. I need to emphasize the significance of public register being land register in case of real estates containing all details of each land and structure and rights attached to them. We have a principle of publicity that real estates may even be acquired from a non-owner because legitimate owner can become despite the fact that the seller was not a real owner. A foreign national may acquire any real estates in the Czech Republic as a natural person or legal entity. All the restrictions concerning the acquisitions of real estates were lifted. Then I want to briefly talk about commercial law, which is guided by the principle of professionalism. In business relationships, due professional care and proper care of good businessmen is required. It is taken for granted that everyone is a professional. Formally, there is no weaker party. Everyone may choose any form of the contract unless being limited by the law, like the purchase agreement for real estates. The specific content of the contract can also be determined by the business terms, or we also take into account the business practice. Forms of doing business in the Czech Republic. We have like few possibilities of doing business. The foreign entity can do so without establishment. A legal entity can establish an organizational unit on the enterprise in the Czech Republic. Then can do business by foreign entities under the Trade Licensing Act. This is connected with establishing an organization unit. Then there is the possibility of ownership interest of foreign entities in the Czech legal entities, which such ownership interests of foreign legal entities are mostly common in spite of not being considered to be true business activities of foreign entities. The last possibility is the relocation of the registered office of a legal entity into the Czech Republic. And of course, we have a special act on cross-border transformation, which allow the cross-border location, merge, transfer of assets, and division. The next is types of business in Czech Republic. We have corporations divided into partnerships and capital companies. Most of the companies are capital, so I shall very briefly concentrate on them. So the capital is the limited liability company, which is the most common form of business in the Czech Republic. Registered capital consists of contribution of partners. Minimum is 1 crown. Partner may own more than one business share. Shares of partners may include various rights. The joint stock company has its registered capital of 2 million crowns, approximately $100,000 US. It has a flexible regulation on rights attached to a share. It is possible to issue various types of shares with various rights. We have two systems of bodies, the dualistic and monistic system. And the last thing I would say with the joint stock company, that they are obliged to have a website whereon they are obliged to publish information stipulated by the law. So the last form is cooperative, but it mainly used for as a form of residential ownership, and it is rarely used in order to conduct business. All the companies have to be registered with the company commercial register. They only very briefly about the state of foreigners in the Czech Republic. The third country national is a citizen that is not member of European Union nor a citizen to above mentioned states. Visa and residential types of third nationalities you can see in my presentation. We have short-term visa, which serves for stays not exceeding 90 days. Then we have long-term visa for a foreigner who intends to stay in the territory longer than 3 months and can be issued for a period of 6 months and can be extended as well. Then we have a long stay, long-term residence. It's for those who intend to reside in the territory for more than 6 months. And the last is the permanent residence, which is issued at the request of foreigner after 5 years of continuous residence, and may be also granted without having met the requirement of this continuous residence of 5 years. So thank you for attention. If you want to have a more detailed information about the Czech legal system, look to my presentation or of course contact my law firm. Thanks for attention.
Thank you very much. I would like to invite our last speaker in this panel, Engineer Michaela Tesarovia, Tax Advisor of CPA and Tax Partners. Please come in.
So good afternoon, ladies and gentlemen. It's my pleasure to be here and to show you some issues of the taxation in Czech Republic. The applicable taxes in Czech Republic are income tax, which is divided into corporate income tax and personal income tax, then the VAT, the excise duties, the road tax, the real estate transfer tax, and the real estate tax. The corporation income tax is applicable for Czech legal entities as well as foreign entities whose place of management is in the Czech Republic. There is only a difference between the taxation of the limited partnership and the general partnership. The income of general partners is taxed at the partners level, and on the other hand, the income of limited partnership is taxed at the company level. The tax base is based on the economic result calculated based on Czech statutory accounting standards and adjusted by the non-tax deductible expenses and non-tax income. The tax base may be reduced by some tax-based allowances, for example, charity donation, in this case up to 10% of the tax base. Another way how to deduct the tax base is to use the tax losses from the previous years. These tax deductible losses can be used within the next 5 years. The income generated by the legal entities is taxed by 19% of the income tax. On the other hand, the income of investment and pension funds is taxed by 5%. The tax period could be either calendar year or the economic year. The economic year is a 12-month period beginning on the first day of the month other than January. The tax return has to be filed and the tax has to be paid till the end of March of the following year, if we are speaking about the calendar year. The date can be extended by another 3 months, but then you have to show to the tax office the power of attorney with the tax advisor or attorney at law. The Czech residents are the individuals with the permanent address in Czech Republic or physically present in the Czech Republic for more than 183 days. These people are taxed on their worldwide income. Other individuals who do not have the Czech tax residency are taxable in Czech Republic only on their Czech source income. The subject of the personal income tax is income from dependent activities, the income from business activities, the capital income, it could be interest income or income of dividends, or the income from silent partnership, then the rental income, and any other income, like, for example, the selling of the property. The current tax rate of the personal income tax is 15%, but this tax rate could be increased by so-called solidarity increase of personal income tax of 7%, which is applicable from the 1st of January 2013 and is applicable for the amount exceeding 1,245,000 of the income. As allowances, we can use the life insurance or pension contribution up to 12,000 Czech crowns yearly, or interest on mortgages up to 300,000 Czech crowns yearly, or charity contribution up to 15% of the tax base, or contribution to trade unions up to 1.5% of the tax base. The final tax can be also deducted by annual personal tax credit in amount of 24,840 Czech crowns, or by the annual tax credit per each child. Individuals working in Czech Republic must generally participate in the Czech social security system and pay the related contribution. The total costs for the social and health insurance for the employer are 34% from the gross salary. The total cost for the employee are 11%. Now shortly to the VAT. So the Czech VAT law is harmonized with EU VAT law. The Czech VAT is levied upon the following transaction as supply of the goods, provision of the services, and transfer of the real estate. The VAT payer is a person or entity having seat in Czech Republic who carry on the economic activities and whose turnover exceed 1 million Czech crowns for a maximum of the past 12 months. The voluntary registration is possible, but then the person has to be able to demonstrate that he carries out the economic activities. The standard VAT rate is 21% and is used on most goods and services. The reduced rate, 15%, is used on books, residential construction services, culture events, and social care services. From the 1st of January 2015, the social care services will be taxed by another reduced rate 10%. The VAT period is calendar months. The taxpayer can decide to apply for a quarterly VAT period, but in this case, his turnover for previous calendar year cannot exceed 10 million Czech crowns. The VAT return and the VAT payment has to be done within 25 days following of the end of the applicable VAT period. The excise duties are very specific taxes, and therefore I am just mentioning the kind of goods on which excise duty is applicable. It's applicable on the hydrocarbon fuels, spirit, tobacco, beer and wine. The road tax is payable for all vehicles registered in the Czech Republic and used for business purposes. The tax period is calendar year, and the tax return has to be submitted and the payment has to be done by the 31st of January of the following year. The tax base calculation is specific for each kind of vehicle. Any transfer of real estate except new building is subject to real estate transfer tax. The tax rate is 4% from the agreed selling price or from the value according to the specific rules. It depends which price is higher. The real estate transfer tax is generally paid by the transferor, but however the parties can agree that the tax will be paid by the transferee. And the real estate tax is imposed on buildings and plots of land registered in the real estate cadastre. The amount of tax depends on their size and location. It's generally paid by the owner. Tax period is calendar year. The tax return has to be submitted by the 31st of January of the actual tax period, and the tax payment has to be done till the end of May of the actual tax period. So thank you for your attention.